Welcome to UO Today. I'm Paul Pepis, Director of the Oregon Humanities Center. My guest today is Henrik Hartog, the class of 1921 bicentennial professor in the history of American law and liberty and professor of history at Princeton University. Hartog is the author or editor of numerous books, including the monographs Man and Wife in America, A History, and Someday All This Will Be Yours, A History of Inheritance and Old Age. He's currently completing a book on the legal culture of the gradual emancipation of the slaves in early 19th century America. Hartog gave a lecture, Justice and Dilemmas of Gradual Emancipation, A Case of Arson in 1815, on April 21st, 2016, as the Oregon Humanities Center's Colin Rowe Thomas O'Fallon Memorial Lecturer in Law and American Culture. His talk was part of the 2015-16 Justice series. Thank you so much for coming on the show.
Thank you so much for having me.
When people think about the work of historians, they often think of studies of these major historical figures, the great men and women who create history. In contrast, you've devoted your career to the study of the social history of American law. What led you there?
Probably stubbornness. I mean, some of it is just the happenstance of when I went to graduate school, when I became a historian. I went to graduate school at the time in the 1970s when social history was, the fashion, history from below, imagining. I still believe this, that history, doing history can be a kind of democratic practice, bringing people who wouldn't be, whose voices you wouldn't hear otherwise, to the front.
So, why is it that studying legal cases gives you access to that?
Well, again, let me start just with my own history, that I'd gone to law school before I went to graduate school. So I had a particular set of, call them skills, reading techniques that I'd learned, and I'd read the work of Willard Hurst, who was a very senior legal historian at Wisconsin, who wrote in terms of a kind of social history of American law, and I was entranced and taken with it. So I wanted to do what he did. Now, I don't think I actually do what he did, but it was something that drew me in. I do remember in the 70s, the other side of the social history of law side was that it was a time when most social historians had a certain kind of, call it Marxist understanding, which was basically that things like law were just surplus, were just the word was superstructure, and relatively uninteresting, wouldn't tell you anything about what really made the world work. So I spent much of graduate school fighting that sensibility, and one of the most amazing things in my life has been that over the past 30 years, people started to agree with me about that, which is sort of, sort of unimaginable to me. But then the other side is that law, the reason people started agreeing with me is they made the same discovery that I did at about the same time, which is that law is an endless repository of sort of details and stories and images of a certain kind of everyday life. It's not really everyday life, but nothing is really everyday life.
Most of your work focuses on the relationship between the law and public and private life in 19th century America. So why is that the period that you focused on? I know you've done work in the early 19th century and the mid 19th century. Why the 19th century? What's important about it?
Some things you need to ask my therapist.
Okay.
I don't know the answer entirely. I find studying the 20th century almost impossible. And most of many of my graduate students do work in 20th century history, and I'm always amazed that they can get anything done because there's too much, the paper record is too thick, too hard, there's too much of it. I'm a little bit like anthropologist or I want something slightly disorientingly different.
Mm-hmm.
And I, the practice of 20th century historians is always, how do we get to who we are today?
Mm-hmm.
And I'm never quite comfortable with that move. On the other hand, I'm not a medievalist. I'm not an early. I want to be able to sort of make some connections.
Mm-hmm.
So what this means, why it is, does this have to do with my toilet training? I'm not sure.
Okay,
that's more than you wanted to know.
Fair enough, fair enough. Your 2002 book, Man and Wife in America, A History, explores the transformation of marriage in early America. Can you give us a kind of overview of that book's argument?
The argument is really that beginning sometime in the late 18th century and going on into probably the post-World War II period, maybe up to the 1970s, marriage is the institution of marriage is in constant tension and transformation. Whatever historians study, they're always finding it in tension. But I think this was there was a structure that reproduced itself even as there was tons of change in marriage. Some of that was about the tension around, much of it was around the tension around the status of women and of married women. For a variety of contingent reasons, married women did have access to the courts, but at the same time they had access to male-dominated courts that were basically insistent on maintaining male privileges. That in itself produces a continuing tension and controversy. The other important factor that sort of shapes this long period is American federalism, that you have a variety of jurisdictions which experimented with different marital regimes. In New York, for example, it was almost impossible to get a legal divorce. Because it was almost impossible to get a legal divorce in places like New York, places like Indiana that were trying to draw white settlers to them made divorce easier. So Indiana becomes, this is an archaic identifier, but the Nevada of the middle of the 19th century. And other states become divorce havens at an earlier time. That creates ongoing constitutional issues because we don't think of it today, though with the same-sex marriage controversy, the same issues arose. Will New York have to recognize the divorce, or more importantly than the divorce, the remarriage of individuals after the Indiana divorce when they move back to New York? Lawyering plays a part in that, but but that's a system in which elements of patriarchy, what the law called coverture, survived. The differential treatment of men and women within marriage, even as there was a lot of tension around those relationships. And the book tries to argue that produces a kind of very unstable but continuing structure that until the post-World War II world, until some things are the Social Security card, the nationalization of marriage rules because of the U.S. Army as much as anything else during World War II, birth control, the entry of women into paid employment, a variety of things, and constitutional and a variety of constitutional languages coming out of the civil rights movement that make the inequality, that make Justice Ginsburg's litigation strategy sensible in the 60s and 70s when she becomes the sort of great litigator who changes so many of these rules. That system breaks down and we end up with the world we are today.
I know that you have an ongoing interest to complicate simplistic and romantic understandings of the past. You've just given us a sense of how complicated your account of the history of marriage in America is. What were the popular myths in that particular case that you were hoping to dispel?
Well, there really is a left and a right version of that.
Interesting.
The left, I mean, the left is the wrong word. A certain kind of feminist version was just patriarchy all the way down. Mm-hmm. And women were merely suppressed until one day when they're no longer suppressed. Mm-hmm. The right version is it was a kinder, gentler world until rights get into the story and mess up everything.
And your picture is one of complication, variation.
Some rights, some discourses. It's never complete suppression. I mean the line I give often to students who say, well, sort of, why did men allow anything? Is men had daughters.
Right.
The judges had daughters, and judges who had daughters worried about the men their daughters might marry, and would they marry the wrong guy, and what would they do under those circumstances.
So this past year, incredible historical Supreme Court decision. Justice Kennedy is writing the official decision, and in this decision he mentions 3 history books, one of which is this book. What was that like?
It was so cool. It was, I know one shouldn't care about that. One's not supposed to, and he's just one reader among many, but it did feel incredibly validating. And actually, though I don't agree with everything in his opinion, and there's things he said that are, well, just plain odd. But in that passage, what he marks is exactly what we as historians have been trying to argue to the court and to other institutions for the past generation, which is that institutions like marriage are contingent historical creations, and that they change over time. Back in 1982, in the case of Bowers v. Hardwick, which is one of the cases that Obergefell and other cases have basically overturned, Justice White's opinion takes the sort of standard, call it myth of marriage, mm-hmm. that marriage has always meant one thing, which we always know what it is, and that we can look back into distant past, and we'll always know what it is at all times. And since 1982, since before then, historians have been pushing against that image of an unchanging institution. And, it was great to have it sort of validated.
I can imagine. So your more recent book, Someday All This Will Be Yours, A History of Inheritance and Old Age, dispels the romantic notion that families in the past cared for their elders out of love and devotion. So
there's still some love and devotion in my story.
So what did you learn about the nature of the care for the elderly in American families during the 19th century?
That, and I still haven't found my one-sentence takeaway, but that for the elderly, if we start from the vantage point of the elderly, in a world without any of the institutions we today that sort of litter our life about old age, I mean, nursing homes, health care, insurance, the commodification of old age, mm-hmm. the fact that you can't turn on a television without an ad about some old age remedy. In a world without that, and in a world where most people, or at least the people I was looking at, people with some modest wealth, but not enormous wealth, in that situation, the only hope for a decent old age you had is if you could keep your children close at hand. If you could keep, or at least some children close at hand to work with you and to help you and to, in the end, care for you when you become less able to care for yourself. And that's a problem. It again goes back to my 19th century. In a world of incredible mobility and in a world of economic growth and a world in which staying on the family farm is no longer the best option for most young people, you had to offer inducements. You had to make it attractive to them. And so what I found, and in a sense this was a story which doesn't come out of unlike the marriage book where I did have a kind of analytic commitment to a particular kind of argument. In this case, it came out of working with a particular set of sources that I didn't know were going to be rich. These sources about the negotiations about inheritance that were a kind of conventional part of every state's jurisdictional law. And they were incredibly rich cases about how people negotiated about family work. Had no idea when I started, but they were so interesting, and I learned such interesting material about who did what work when, how you did it, how you paid for it, how you didn't pay for it. So they were just a kind of cool source, and I just, this is the nerdy historian. I just fell in love with this source. I didn't know it was really about the history of old age when I started. I thought they were contract cases. They were clearly family contracts. I was interested in family contracting. But I one day walked, sort of nose first into a stack in Firestone Library at Princeton, which was a stack devoted to the history of old age. And it was like, oh, that's what I've been reading. That has partly to do with the fact that the history of old age in the U.S. is a relatively weak discipline, while there's a much stronger European discourse.
Can you share one of the cases that one of the interesting illuminating cases?
Well, this is maybe not for primetime radio or whatever. There's this one, endless one about, with more detail than you can possibly imagine, from this nephew about how he gave his uncle an enema. And just, you don't imagine things like that in a courtroom or in a 19th century puritanical courtroom. But this incredible detail about what it meant to do that, and then what it cost him and how he should feel he should get compensated for that. I have lots of cases about, poor, by the time they're in court, they're middle-aged, younger people who've basically devoted 20 years of their life to some truculent, eventually demented old individual or couple who make their lives living hell. And then, the cases come into being because the young people have found out that they didn't get what they were promised. So they have to impose on the courts what might be called a labor theory of value. They have to convince the courts that the work produces entitlement.
Because there were no contracts.
Nothing ever gets written down. They're family. And so everybody, and I think the older people, this is speculative on my part, I think the older people played on that family dynamic, said, oh, you can trust me, I'm your father, or I'm your uncle, or I'm whatever, and of course I'll take care of you. But then, either they quarrel just before marriage, or the old guy finds a new love, or he simply declines too fast before having written the will that he's promised to write, or she has promised to write.
And then the one sibling who did the primary care, it gets the majority of the estate, and then the two brothers sue the sister.
It can be any number of. You can map out all the different possible stories, but they all happen. And
just fascinating. So your current book project, or one of your current book projects, concerns the legal culture of the gradual emancipation of the slaves in early 19th century America. My first question, I'm just, I'm a layman. gradual emancipation? Wait a minute, there was the Emancipation Proclamation, so the day we didn't have it and then we had it. What is this gradual emancipation?
Well, that's the whole point. That's, we all think that. I sometimes think of this as the neo-abolitionist mindset, which we've all, since the 13th Amendment, has become how all of us think emancipation works, that somebody flips a switch. And, you know, the phrase, Lincoln freed the slaves, it can be a sort of, somebody did it, and it just happens. Now, something like that did happen to millions of enslaved African Americans between 1862 and 1866, though the lever of that was their own actions in just walking away or running to Union lines, and the Union Army itself. I mean, that made that happen. I mean, you had to have a massive, earth-shattering war in order to have that switch. Over the previous centuries, there have been many emancipations, but they've always been compensatory emancipations. They've always been gradual in one form or another. They've all taken more or less indistinct forms. So in some ways, I'm just globalizing a story that we tend to see through this peculiar mid-19th century lens. I'm particularly interested in New Jersey. Partially, I live there. Okay. And so I want to.
But there are sort of historical reasons why New Jersey is a particularly interesting test case.
Yes, I mean, one of the interesting things is that of the northern states, New Jersey never completely abolishes slavery. New Jersey's gradual emancipation lasts from, well, formally from 1804, but really from the last years of the 18th century until after the 1860 census. In 1860, the New Jersey census still lists 18 slaves in the state. Now, they're in New Jersey law by then, they're called apprentices for life, but they are basically still enslaved people. My joke about this is that in 1865, the Democratic-controlled New Jersey legislature votes down the 13th Amendment. So one could say that New Jersey never abolished slavery. But I mean, put that aside, I mean, basically for 2 generations, New Jersey is living through a regime that one might call the regime of gradual emancipation. It's an in-between world. Probably many people didn't believe in slavery, but there were still slaves. It was relatively easy to get away from slavery if you were an enslaved person. All it took was getting on a ferry boat and disappearing in the free black community in New York or in Philadelphia. But there still was slavery. There was incredible the legislature keeps passing laws about it. So that's the world that it's the mess. I guess you're right. It's another situation where what draws me is the messy in-betweenness of things.
Fascinating. So tell us about the research for this book. So what are the things that you're looking at? You've told us some interesting stories about your research for the other book.
Mostly a series of cases. So, in the lecture I talk about this particular arson case, where a house is burned down by somebody's slave, except he wasn't really a slave, he was really free, or the question of whether he's free or enslaved is the central question. In 1821, Thomas Gibbons, who is the early steamboat entrepreneur and engaged in a sort of war to the death with Aaron Ogden, who's his rival for control of the steamboat trade, is arrested for having allowed a slave to escape on one of his boats. He had, on the 4th of July, 1818, allowed free passage for anybody on his boats as a lost leader to draw business this battle over the steamboat trade between New Jersey and New York. Somebody enslaved person got on the boat and disappeared, and the owner then sues him for the value of the slave. He says, who am I supposed to know who's a slave and who's not? There are more free black people in the state than there are enslaved people. So in 1821, at a time when there are far more free people than black people, than enslaved people in the state, the New Jersey Supreme Court creates a presumption of slavery, basically creating a pass law. I mean, it's like South Africa, a pass law that you can own. Now, it doesn't work, but for the next 15 years, there's a series of cases in which that problem and the problem of individual black people getting on boats is litigated over and over again, and the courts can't figure out what to do with it.
Fascinating, fascinating. So we just have a couple of minutes left. Sure. We've talked about how you're interested in sort of dispelling mythological understandings of the past, and you've talked just now about how this new book is aiming to do that, but we've also talked about the unexpected relevance of your book on marriage to very contemporary debates. Do you anticipate this work on gradual emancipation will be resonant in the current discussions and debates about race in America?
I'd like to think in the sense that what I'm trying to describe are the moral and legal lives of individuals in situations where they all articulate and express what might be called false consciousness of various sorts. All of us depend on migrants from around the world for much of our labor. Our gardens are cleared, our plates are cleared in restaurants. The people who care for our elderly parents are almost all migrants from the rest of the world, some of whom are legal, some of whom are quote unquote illegal. And we live, and then we voice all sorts of opinions about that. We live, in a sense, the anti-abolitionist view is we think we flipped into a world of freedom, but of course we live in a world of immense complexity. And I think I'm describing a similar world for the early 19th century.
That's a wonderful note to stop on. Thank you for describing the very complex world that we came from and where we're going. It's been a real pleasure talking to you today.
Okay. Thank you.
I've been speaking with Henrik Hartog, the class of 1921 bicentennial professor in the history of American law and liberty and professor of history at Princeton University. Hartog gave a lecture, Justice and Dilemmas of Gradual Emancipation, a Case of Arson in 1815, on April 21st, 2016, as the Oregon Humanities Center's Colin Rowe Thomas O'Fallon Memorial Lecturer in Law and American Culture. His talk was part of the 2015-16 Justice Series. Thanks so much for watching.